I would never be begging a nigga to be with me after he got a baby on the way. I would never be having matching t-shirts on with a nigga that got a baby on the way. I would never be trying to play family with a nigga that got a baby on the way. I would never want to be with a nigga that done got so many bitches pregnant during the time that I've known him. I would never want to be with a nigga like that.
6 murder charges, 1 victim, 1 crime, 1 day. You're probably thinking, that's impossible. How do you charge someone 6 times for the same murder? Well, in Illinois, it's absolutely possible. And Holly Johnson's life is almost over because Illinois doesn't do second chances. Illinois doesn't do parole. Illinois doesn't do early release. And when you stack 6 Class M felonies with firearm enhancements and consecutive sentencing, you don't get a prison sentence. You get a death sentence. Before we go any further, hit that subscribe button, smash the like, and drop a comment below. Tell me, should Holly take a plea deal or risk trial? I want to hear your thoughts. Now let's talk about what's about to destroy her life. Class M felony. Right now you're asking yourself, what the hell is a Class M felony? It doesn't officially exist. It's not in the Illinois Criminal Code. It's courthouse slang. What prosecutors and defense attorneys call first-degree murder when they're negotiating in back rooms, when they know someone's life is about to end. The M stands for murder. And it exists in its own category because first-degree murder doesn't fit anywhere else. Here's why. Illinois ranks felonies from most serious to least serious. Class X, Class 1, Class 2, Class 3, Class 4. Class X is the worst: armed robbery, aggravated kidnapping, predatory sexual assault. You're looking at 6 to 30 years, straight to the Department of Corrections. But first-degree murder? The sentencing range is 20 to 60 years minimum, and that's before firearm enhancements, before aggravating factors, before consecutive sentencing. First-degree murder doesn't fit into Class X. It's worse, so lawyers call it Class M. And here's what destroys defendants. You can be charged with multiple counts of Class M for killing one person, not because you killed multiple victims, but because there are multiple legal ways to prove you committed murder. Illinois Statute 720, ILCS 591, recognizes several theories of first-degree murder. Each theory is a separate count. Each count carries 20 to 60 years minimum, with the possibility of natural life. So when Holly Johnson shot Romeca Blackmon 3 times in the face on September 8, 2025, prosecutors said, "We can prove this murder 6 different ways." 6 separate charges, 6 separate chances for the jury to convict. Let me break down those 6 counts. Count 1. Intentional killing. Multiple witnesses heard Holly yell, "I'm going to shoot you. Watch me shoot you." That's intent spoken out loud. Count 2. Knowledge that actions would cause death. Firing a 9mm at point-blank range into someone's face, Holly knew exactly what would happen. Count 3. Strong probability of death. 3 shots. Face, chin, side. That's not random firing. That's deliberate targeting of vital areas. Count 4. Felony murder. Prosecutors will argue Holly's gun was illegally stored, making Romeca's death occur during the commission of a felony. This count is the weakest, but juries can still convict on it. Count 5. Accountability. Carlos Smith restrained Romeca while Holly retrieved her gun. Witnesses saw Carlos put Romeca in a chokehold. That's a coordinated act. That's conspiracy. Count 6. Aggravating circumstances. Premeditation. Holly filed protective orders months before the shooting. Lying in wait, they positioned themselves at Romeca's son's school. Vulnerable victim. Romeca was physically restrained and couldn't fight back. Proximity to a school. Child present. Their 6-month-old was in the car. Consciousness of guilt. After Romeca fell, Holly and Carlos fist bumped, and Carlos said out loud, "It was self-defense, right?" 6 counts. Same victim, same crime, same day. Each count carries 20 to 60 years, or natural life. The jury doesn't have to convict on all 6, just one. But if they convict on multiple counts, the judge can stack those sentences consecutively, back to back, not simultaneously. 6 45-year sentences stacked? That's 270 years. Holly Johnson is 31 years old. She's not living to 301. Consecutive sentencing guarantees she dies in prison, without the judge ever having to say the words, natural life. Now we need to talk about the legal mechanism that seals Holly's fate: mandatory firearm enhancements. Because even if the jury only convicts on one count, even if the judge feels sympathetic, none of that matters. The firearm enhancement is automatic. It's written into Illinois statute, and it turns a 20-year minimum sentence into 45 years to life. Here's how it works. Illinois Law 730 ILCS 5581 establishes mandatory add-on sentences for defendants who commit first-degree murder with a firearm. These aren't suggestions. They're not guidelines. They're mandatory. The judge cannot waive them. The judge cannot reduce them. The judge cannot ignore them. If the facts meet the criteria, the enhancement applies automatically. There are 3 tiers of firearm enhancements, and each tier adds more years to your sentence. Tier 1. Personally armed with a firearm during the offense. If you had a gun on you when you committed first-degree murder, you get an automatic 15-year enhancement. Instead of 20 to 60 years, you're now looking at 35 to 75 years. Tier 2. Discharged a firearm during the offense. If you actually fired the gun, the enhancement jumps to 20 years. Now you're looking at 40 to 80 years minimum. Tier 3. Discharged a firearm and caused death or great bodily harm. If you fired the gun and someone died as a direct result, you get an automatic 25 years to life added to your sentence. This is the highest tier. This is where Holly falls. Holly didn't just carry a gun. She didn't just have it in her possession. She fired it 3 times. She hit Romeca in the face, in the chin, in the side, and Romeca died. That's Tier 3. That's the maximum enhancement. That's 25 years to life added automatically to whatever base sentence the judge imposes. So let's do the math. The base sentence for first-degree murder in Illinois is 20 years minimum. Add the Tier 3 firearm enhancement, 25 years to life. 20 plus 25 equals 45. That's Holly's absolute minimum sentence if she's convicted on even one count. 45 years at 100%. No parole, no good behavior credits, no early release, every single day served. But 45 years is just the minimum. The judge has discretion to go higher. The maximum sentence for first-degree murder with Tier 3 firearm enhancement is natural life in prison. Natural life means exactly what it sounds like. You die behind bars. You never see freedom again. You serve until you take your last breath in a Department of Corrections facility. Now let me tell you something most people don't know about Illinois. Illinois is one of only 3 states in the entire United States that has completely abolished parole: Illinois, Maine, and Virginia. That's it. 47 other states have some form of parole system where prisoners can earn early release based on good behavior, rehabilitation, time served. But not Illinois. In Illinois, when that judge bangs the gavel and announces your sentence, that's exactly how long you serve. Not a day less, not a day more, every single day. And it gets worse. Illinois doesn't just refuse to grant parole. Illinois also refuses to give good time credits to people convicted of first-degree murder. Good time credits are what most states use to incentivize good behavior in prison. You stay out of trouble, you participate in programs, you show you're rehabilitated, and the state knocks time off your sentence. In most states, good behavior can reduce a 40-year sentence to 30 years, 25 years, sometimes even 20 years. Not in Illinois. If you're convicted of first-degree murder in Illinois, you get 0 good time credits. 0. You cannot reduce your sentence through good behavior. You cannot earn credits for participating in educational programs, vocational training, substance abuse treatment. Nothing. You serve 100% of your sentence. Every single day. Now let's talk about the thing that turns a life sentence into an impossible sentence: consecutive sentencing. If Holly is convicted on multiple counts, and remember, prosecutors are charging 6 counts for the same murder, the judge doesn't have to make those sentences run at the same time. The judge can stack them one after another, back to back. Here's the difference. Concurrent sentencing means your sentences run simultaneously, 3 counts, 45 years each. If those sentences run concurrently, you serve all 3 at the same time. Total time: 45 years. Consecutive sentencing means your sentences run one after another. Same scenario: 3 counts, 45 years each. But now the judge orders them to run consecutively. You serve 45 years for count 1. Then when those 45 years are done, you start serving 45 years for count 2. Then 45 more for count 3. Total time: 135 years. In Illinois, judges have broad discretion to impose consecutive sentences for violent felonies, and first-degree murder is the definition of a violent felony. So if Holly is convicted on 2 counts, the judge could sentence her to 45 years on count 1 and 45 years on count 2. Consecutive. 90 years total. 3 counts, 135 years. 4 counts, 180 years. All 6 counts, 270 years. Obviously, 270 years is meaningless in practical terms. Holly isn't living to be 301 years old. But that's exactly the point. Consecutive sentencing is how judges impose de facto life sentences without actually saying the words natural life. It's a mathematical guarantee that you die in prison. And here's why prosecutors absolutely love consecutive sentencing. It's appeal-proof. Think about it. If Holly is convicted on 6 counts and sentenced consecutively, she could spend 10 years appealing count 1. Maybe she wins. Maybe an appellate court finds an error and overturns that conviction. Great. She just knocked off 45 years. But she's still got 225 years left on the other 5 counts. She's still dying in prison. She'd have to successfully appeal and overturn all 6 convictions to walk free. And the odds of that happening are so close to 0, you might as well call it impossible. So what's Holly's way out? There's only one option: a plea deal. But even that is a life sentence. Let's be completely realistic about Holly Johnson's situation. She has 2 options: take a plea deal or go to trial. And if she's smart, if her attorney is worth the money she's paying him, she'll take the plea, because going to trial means gambling with the rest of her life. And the house always wins. Here's what a plea negotiation looks like in a case like this. The prosecution comes to the table with all the leverage. They've got multiple witnesses who saw Carlos restrain Romeca. They've got witnesses who heard Holly yell, "I'm going to shoot you, watch me shoot you." They've got witnesses who saw the fist bump after Romeca fell. They've got autopsy evidence showing the trajectory of the bullets proves Romeca wasn't attacking. She was standing still or already falling. They've got evidence that Holly's gun was illegally stored, which undermines any self-defense claim. They've got everything they need to convict. So the prosecution offers a deal: plead guilty to second-degree murder. We'll drop the first-degree charge. You'll get a reduced sentence. You'll avoid natural life. And most importantly, you'll have a release date. Second-degree murder in Illinois is a Class 1 felony. The sentencing range for Class 1 felonies is 4 to 20 years. That sounds way better than 20 to 60 years for first degree, right? But here's the catch that destroys that math. Prosecutors may still insist on firearm time, depending on how the plea is structured. And in most plea scenarios, the Tier 3 firearm enhancement doesn't just disappear. She still discharged a firearm. She still caused death. That means the mandatory 25-year enhancement can still be added to whatever sentence the judge imposes for second-degree murder. So let's do the plea deal math. Holly pleads guilty to second-degree murder. The judge sentences her to the maximum, 20 years for the Class 1 conviction. Add the mandatory 25-year firearm enhancement. 20 plus 25 equals 45 years total. But wait. Here's where it gets slightly better for Holly. Second-degree murder convictions may be eligible for 50% good time credits, unlike first-degree murder, which requires you to serve 100%. So Holly could serve 50% of the 20-year Class 1 sentence if she maintains perfect behavior in prison. That's 10 years. But the 25-year firearm enhancement is served at 100% because it's tied to causing death. 10 plus 25 equals 35 years total. Holly is 31 years old right now. 35 years from now, she'll be 66 years old when she walks out of prison. 66, if she makes it that long, if she doesn't get killed by another inmate. If she doesn't die from inadequate medical care, if she survives 3.5 decades in the Illinois Department of Corrections. But here's why Holly should take that deal. Because the alternative is catastrophically worse. If Holly goes to trial and loses, and the evidence strongly suggests she will lose, she's facing 45 years to life on first-degree murder with firearm enhancements, all of it served at 100%. No good time, no reductions. If the judge stacks sentences consecutively on multiple counts, Holly could get 90 years, 135 years, 270 years, or natural life. All of it served at 100%. So the choice is brutally simple. Take the plea, serve 35 years, walk out at 66, or roll the dice at trial and possibly die in prison. Holly's attorney is going to sit down with her in that county jail visitation room and lay it out in the bluntest possible terms. Holly, I can't guarantee we'll win at trial. The evidence is strong. The witnesses are credible. The jury is going to see that fist bump. They're going to hear you say, "I'm going to shoot you." And when they hear all of that, they're going to convict. And when they convict, the judge is going to throw the book at you. You'll get 60 years, 80 years, natural life. You'll die in prison. But if you take this deal, you'll get out. You'll be old, but you'll get out. You'll see your daughter again. You'll have a life. It won't be the life you wanted, but it'll be a life. Take the deal. And Holly will take it. Because 35 years is better than natural life. 66 years old is better than never. Having a release date is better than dying behind bars. But let's be clear about what a plea deal actually means for Holly. It's not mercy. It's not leniency. It's not getting off easy. 35 years is a life sentence. Holly's daughter will be 35 years old when Holly gets out. Holly will miss her daughter's entire childhood. Graduations, proms, first jobs, weddings, grandchildren. By the time Holly walks out of prison at 66, everyone she knows will be elderly or dead. The world will have changed completely. Technology will be unrecognizable. And Holly will be an old woman with no job skills, no education, no connections, no support system, released into a society she no longer understands. That's what a plea deal gets you in Illinois. It's just a slower death. Before we wrap this up, do me a favor. Hit that subscribe button. Smash the like, share this video, and drop a comment below. Will Holly take the plea or risk trial? What do you think Carlos should do? I want to hear your thoughts. And Holly Johnson isn't the only person facing life in prison for Romeca Blackmon's murder. Carlos Smith, the father of Romeca's 6-year-old son, the man witnesses say restrained Romeca while Holly retrieved her gun, he's next. Right now, as of January 2026, Carlos hasn't been charged. But he will be. Prosecutors are waiting. They're building their case. They're waiting to see if Holly flips. They're waiting to see if Carlos will cooperate and testify against Holly. And once they have everything they need, they'll charge him. Illinois has a legal doctrine called accountability. And accountability means if you help someone commit murder, you're just as guilty as the person who pulled the trigger. If Carlos knew Holly was going to shoot Romeca, and Carlos did anything at all, to help make that shooting happen, Carlos is guilty of first-degree murder. Same charge Holly faces, same sentence range Holly faces, even though Carlos never touched the gun. And the evidence against Carlos is damning. Multiple witnesses saw him restrain Romeca. They saw the coordination. They heard him say, "It was self-defense, right?" Right now, both Holly and Carlos are sitting in silence, hoping the other one doesn't crack. But eventually, one of them will. And when that happens, the other one is finished. By all accounts, Illinois is the harshest state in America. Only 3 states have abolished parole. Only Illinois requires 100% of first-degree murder sentences to be served. And with truth in sentencing laws, mandatory firearm enhancements, and consecutive sentencing, Holly Johnson will never be free again. Her only hope is a plea deal to second-degree murder. And even with that, she's facing 35 to 40 years behind bars. She'll be 66 to 70 years old when she gets out. If she gets out at all, that's still a life sentence. Romeca Blackmon was 31 years old. She was a nursing student, a devoted mother. She deserved better than to be shot 3 times in the face in broad daylight while her 6-year-old son was at school. And Holly Johnson is about to spend the rest of her life paying for what she did. Subscribe for updates on this case. Drop a comment. Will Holly take the plea or risk trial? Share this video, hit that like button. And remember, in Illinois, murder means life. There's no parole. There's no way out.